So, our talk is titled Using LLMs to Assist Regulatory Order Writing. This is a collaborative effort between a few of us here at Trustbridge and with Dono Consulting, our partners on this project. While we've had the advantage of getting early feedback from a number of people and the support of many others whose inputs have helped our work, both within Trustbridge and from people like Ajay, I should, before I jump in, take a moment to acknowledge the core team of 5 people who are working on this. Amrutha and I are part of that team. We'll be presenting, but Natasha Agarwal is also here. She's from Trustbridge. Deepaman Sanyal from Dono Consulting is here with us. And another person from Dono, Satya, is also collaborating with us. So just want to acknowledge the 5 people working on this. And with that said, I will jump into this. Here's a quick overview of what we hope to talk about. The idea for all of this work is something that's been spurred by a number of things that we've been hearing in the discourse about AI, and particularly AI's use in the state and particularly in judicial and quasi-judicial settings recently. So I want to start off by mentioning 2 incidents, and I'm sure at least one of these is very familiar to a lot of us. Towards the end of last year, the Bangalore bench of the Income Tax Appellate Tribunal apparently released an order which was suspected to have been written using a generative AI tool, something like ChatGPT. And the reason that people suspect this is because it was based on 4 cases that are entirely made up. So some system hallucinated 4 orders, and somebody on the ITAT bench said, okay, I'm going to use it and put it in an order anyway. That order was later withdrawn quite hastily. And something else that we've noticed in the course of our work is that even without the use of LLMs or other generative AI technologies, we have serious problems with how orders are written in the country today. And as one example, we have seen how SEBI has taken an inconsistent stance on something that is core to adjudicating insider trading matters, which is what is the standard of proof that you require for that. Incidents like this do a couple of things. They show that the use of LLMs in certain settings is extremely risky. There are many, many problems that could come with that. But the case of SEBI taking an inconsistent stance on something like the standard of proof also highlights the need for improvement in regulatory order writing practices in the country today. The second thing that instances like this do is to push the conversation to extremes. At the one end, you have an extreme fear of these technologies, saying that, look, they're so full of problems, they hallucinate, they're black boxes, we don't know how they work, they could be biased, and so we should never let them into this sort of situation at all. And at the other end, you have some sort of technocratic reaction which says, no, order writing is bad anyway, so we should just use technologies and throw all the people out of the equation. And we feel that both of these extremes are undesirable. Neither of us points us towards any sort of implementable solution. And the general discourse on the use of LLMs and AI in judicial, quasi-judicial settings seems to stop at either of these 2 ends. On the one side, you will have literature which points to the many attendant problems of using these technologies. But we haven't noticed anything in the Indian literature which asks the question, if you were to use these technologies, being completely cognizant of the problems that attach to them in such settings, what are the principles of administrative law that you should be aware of? How do you go about satisfying and addressing these principles? And so the contribution that we seek to make is to identify the core set of problems that you could run into if you were to use these technologies in such settings. What are the administrative law principles that these problems impinge upon? And finally, if you were to try and address these principles, could you consider a framework which has 3 parts? There are problems, but there are potential solutions for each of these problems. And then there could be evaluations that tell you whether or not the solutions that you propose are working. And so that's what we want to take you through over the course of the next half an hour or 40 minutes or so. So we're going to focus not just on the problems, we're going to focus on what we think are the principles of administrative law that are involved here and how you could go about addressing those through a problem solution evaluation frame. Now, we've looked at 6 main problems that we think you should think about. In all cases, they may not relate to an administrative law principle. Nonetheless, there are certain problems with the use of LLMs which we think are of particular concern when you're thinking about a judicial or a quasi-judicial setting. And so 2 out of the 6 problems that we talk about fall into that category. But we propose to talk about those as well. And Amrutha will address why we think it's important to talk about that. Now, with that said, I'm going to move on to the next section and hand over to Amit.
Thank you, Bhavin. I hope that I am sufficiently audible. There's not much I can do about it, but please bear with me. So before we dive into our discussion on the potential opportunities and challenges that we think LLMs present when they are used to assist in regulatory order writing processes, I'd like to very briefly present a high-level overview of a select few features of LLMs and how they work to foreground the discussion that follows. So this is by no means a full overview of the technical specifications of how these technologies are built or designed to function. But there are a few features that we think become relevant in terms of the tensions that may emerge when they interact with the principles of administrative law. So let's break this down a little bit. Can we move to the next slide, please? Right. So let's begin with breaking down the term large language models. Language models are essentially computer programs, very, very crudely, that can follow instructions and generate output in natural language. And they achieve this by essentially acting like an incredibly sophisticated autocomplete system. What they're actually doing isn't so much creating in the human sense of the term, but rather they're just meticulously predicting the next most likely word in a sequence of words and building sentences and paragraphs word by word. Now, they're able to do this because they are trained on bodies of text from which they learn patterns in language, such as the relationship between words. For instance, which words are most likely to precede and succeed one another, the rules of syntax, grammar. They pick up these patterns from the text, and then they replicate these patterns by predicting the next most likely word based on their learning. Now, large language models are characterized by the sheer scale at which they do this. So they're typically trained on vast training data sets, and they have billions of parameters, which allow them to make little internal adjustments to what they believe should be the next most likely word based on the context of the other words in the vicinity of the word they're about to predict. As a result, they can produce text that seems coherent, it seems logically consistent, and it gives a sense of almost being well-reasoned. But fundamentally, what they are is probabilistic models. So they are based on computations of probability. Now, there are 3 implications to this probabilistic nature of LLMs for our analysis. Firstly, I've told you that language models work by learning from bodies of text that are fed to them. Now, as a consequence of this, the quality and nature of the data that you feed them, the text that you feed them, and the prompts that you give LLMs at different stages of its workflow have a direct bearing on the nature of the output they're able to generate. It may be very useful to leverage, say, an LLM that is trained on vast troves of Reddit threads for a conversational bot. But this LLM may not be very useful in navigating highly specialized, formalized, and domain-specific tasks, such as the ones involved in order writing processes. An LLM that you intend to use to assist order writing processes must be one that is built on a highly specialized legal database. This is because the meaning of words and the relationship between words are very, very specific and have very specific meanings in the legal domain. Therefore, an LLM application that is intended to be used in order writing to assist order writing processes must be trained on a specialized and carefully curated data database. Secondly, Bhavin alluded earlier to the problem of hallucinations when he talked about the Income Tax Appellate Tribunal's order. So we understand hallucinations essentially as the tendency of LLMs to make things up. Now, this is problematized a lot in the discourse that, oh, we can't trust them because they make things up. But we know from the way that LLMs work that they're simply always playing an elaborate linguistic guessing game. They're always trying to guess what the next word is going to be. So by extension, their tendency to make things up is not an anomaly. They don't just make things up sometimes when they glitch. They make things up all the time by design. This is a feature of LLMs and it's not a bug. They do not understand the meaning of words or the relationship between words, the implications that words have in the way that humans do. And sometimes their tendency to just make things up is very well suited to the user's context, especially in tasks that require a certain degree of linguistic creativity. But they become problematic when two conditions are met. First, they produce an output that is irrelevant or inaccurate to the user's context. And second, the user in turn simply accepts this inaccurate but coherent output without verifying its suitability to their context or checking to see if it is accurate. So the dangers of this accepting an LLM's output without verification are especially aggravated in the context of legal or regulatory settings. Now, the third thing I want to point out with respect to how LLMs work is that, again, I've told you that because they're probabilistic, how they work is on the basis of extremely complex statistical models. So what they do is they perform a series of mathematical operations to go from input to output. Now, as a result, their internal decision-making processes are not always decipherable to the average user or to any user. And this problem is popularly known as the black box problem. What this means for us is that the steps an LLM takes to arrive at a particular answer are not reasoned in any human sense of logic or deliberation. Rather, they are the result of complex statistical probabilities. And consequentially, their exact pathway of how they got from input to output is not always decipherable to us. It's not always clear to us. So broadly, these are some of the features that I want to highlight to you to foreground the analysis that follows. And with that, I'll hand it back over to Bhavin to address the next part of our presentation.
Thanks. So I think what we've got so far is that LLMs work and function in a certain manner, and it is unavoidable, given the way that they are made, given the way that they function, that there will be certain problems. So let's just take 2 or 3 of the ones that Amrutha has pointed out. We'll add more later, but let's just keep that list going as we go along. So there is the problem of hallucinations. There is the problem of the black box. We have at least these two. And we've heard a little bit about how they might be trained on certain chunks of text. That text might have certain embedded biases. And so there is a third category of problems that we can already identify, which is bias. So you've got these three. These are unavoidable, more or less, if you're going to use LLMs. So the next question to ask is, are LLMs being used in the legal domain in any situation at all? And what can we learn from such uses? But first, why are we doing this at all? So why are we talking about LLMs to assist good order writing? We've pointed out that there are certain problems with the way that orders are written in India today. And one of the things that we've learned is that there is very little investment in technology to improve order writing practices. While there is a fair investment in technologies in areas such as surveillance by SEBI, for example, you don't find a corresponding investment in order writing practices. We're not suggesting for a moment that order writing is a monolithic exercise, nor are we suggesting that there is a simple one-click solution to fixing all of these problems, which is just have LLMs write orders. So if at all you came here thinking that we're proposing a solution where there is a chat box and somebody enters the problem and uploads some pleadings and gets a draft order, that's not at all what we're alluding. I should point out first that we think of the order writing exercise as an extremely complicated exercise which involves several tasks. We think there is room for intervention and improvement using technology in many of these tasks. All such interventions cannot and should not be through the use of LLMs. At a very simple level, there are ideas such as using traditional forms. And if you have a form or if you have a logical template that can understand conditions, that can branch out depending on what we're dealing with, then a lot of this can be taken care of right there. You don't necessarily use LLMs to do this. But that said, there are certainly some other tasks where there is a room for thinking about how LLMs could help. Some examples of these are reviewing a draft order that has been written by a human, perhaps through the use of a conditional form or without any technology at all, to look for and suggest applicable precedent from a precedent bank. And this is something that we're not aware of as existing in regulatory practice in India today. And finally, to review the language of the order and make stylistic suggestions so that it is decipherable, so that it is something that the affected persons can understand. A lot of these suggestions come from some arguments that we had made in one of our previous papers, which we call the good order writing paper, where we made 4 sets of requirements. We'd identified 4 sets of requirements, which we suggested should appear in all regulatory orders. And we think that the use of LLMs can help in each of those 4 areas. So here are some examples of how LLMs might be able to assist the order writer in each of those areas. We've seen in our survey of regulatory orders at scale that these orders often miss basic information which affected parties and anybody else who's concerned with these orders should have available. And so one simple task you can assign an LLM is to say, is this order complete? Does it have all the information that it should? You can then ask if it's structured in the appropriate manner. The structure is not a mere aesthetic requirement. It is also something that strengthens the logic of the regulatory order, strengthens the logic of the argument. And so it is an important part of how an order should be written and how it should be thought about. Then there's the substantive requirements. Have you addressed all the requirements of the law? If you are, for example, imposing a particular sort of sanction on somebody for a violation that you think that they have committed, is this consistent with sanctions imposed on similar violations in the past? Should your standard of proof be X or Y? And so how can you avoid the sort of inconsistencies that we've seen in the insider trading cases in the past? And for that, you need something that can go look up a precedent bank and suggest something useful to you. And finally, there are certain standards of checking for legibility, understandability, comprehensibility of written text. The Fresh-Kincaid test is a readability test. There are other similar tests. And an LLM might be used to suggest improvements to the way in which the order has been written to make it more comprehensible and accessible to affected parties. So with that said, how has this happened in other jurisdictions? Has anybody attempted to use LLMs in judicial or quasi-judicial settings at all? And if they have, what sort of guardrails have they put around the system? What sort of frameworks have they thought of? What sort of guidelines are in place to ensure that the problems that we've talked about and the problems that have been identified are not encountered in practice? So we've looked at the design principles that have been articulated in certain national policies for the use of AI in such settings. And we've also tried to do a survey of how these technologies are indeed used in such situations. And we've then tried to say, okay, if you have certain design principles that these nations have adopted, what Indian administrative law principles do they map on to? What do they correspond to? Because remember, that's essentially what we're trying to drive to. We're trying to drive towards how do you satisfy the requirements of Indian administrative law. And so what are the learnings from other jurisdictions and how has this been applied? How does this relate to Indian administrative law? Just to give you a couple of examples of the sort of applications and uses we've looked at, there has been, of course, the use of AI, not LLMs in particular, in the faceless assessment scheme in the Income Tax Authority in India. Similarly, you have the use of an IBM designed system in Germany, which is deployed to review orders. There are other instances in other jurisdictions of AI systems looking at very minor violations, such as traffic violations and so on. But very interestingly, we are able to point to at least 4 or 5 countries that have used LLMs in judicial or quasi-judicial settings to various extents. So here's a quick overview of some of the jurisdictions that we've looked at. And on the first column of the left is a set of principles that we think that the policies of these jurisdictions articulate. On the extreme right of the table is our understanding of what we think the corresponding Indian administrative law principles are. You might have noticed already that there's one cell which is blank on the right. This just means that that issue may not be addressed in administrative law. It may be addressed in some other field or domain of law. And there is probably an answer to it there, but we remain focused on what are the sort of Indian administrative law principles that are involved here. The question now becomes, how do you go about addressing things like arbitrary, so the rule against bias or non-application of mine? Given what we know about how LLMs work, everything that Amrutha already told us, is this even possible? Is it even feasible? And that's the part that I want to start moving on to now. So we think that if you look at the sort of problems that LLMs throw up, there are 5 main principles of Indian administrative law that you need to start worrying about. These are the problems of non-application of mind, a failure to provide reasons, arbitrariness, rules against bias, and transparency. And so I want to take you back a few slides to the features of LLMs that Amrutha talked about and how they will inevitably create certain problems. So if the LLM is a black box, and if we don't understand how it works, then how do we even attempt to address the requirement to provide reasons? Maybe there are some other problems as well, which don't map onto Indian administrative law, but perhaps that's just because these questions have not been raised in the Indian administrative law discourse just yet. Simply because these technologies are new, these questions are new. And maybe these questions will come up and maybe we'll start getting answers in some time, but we're happy to start asking the questions a little in advance anyway. So we think the way to think about this is to list down all your problems and then say, okay, how can we think of certain solutions that could address these principles, these problems? And finally, let's not leave it at that. Let's try and consider whether any evaluations can be implemented to determine the efficacy of these solutions. Any shortcomings, anything that we can't fix with the solutions and that comes up in the evaluation goes back into the loop and we try and think of better solutions. So I'm going to hand this back to Amrutha now and ask her to elaborate upon both the problem solution evaluation framework and perhaps talk us through how exactly each of these addresses administrative law concerns and maybe give us an example or two.
Thank you, Bhavin. So there are three parts to the framework, like Bhavin said. There's first the articulation of problems. Then there are solutions that are mapped out to each of the problems and evaluations to test the efficacy of the solutions. So in our conceptual framework, we, like Bhavin told you, identified 6 broad problems. We also identified 3 categories of solutions and 4 possible approaches to evaluate these solutions. I'll walk you through each of these components now. So the first bit that we're interested in is articulating the problems. So as you can see in this table, we have mapped out a total of 6 possible problems that we think might be relevant when LLMs are leveraged to assist with order writing practices. Now, I want to specifically highlight the last 2 challenges on this list. So this calls back to what Bhavin said a few minutes earlier about how, while these problems, the problem of one, having a specialized legal database to serve as a training corpus to build such an application, and second, the problem of data privacy and security in terms of sensitive information being present in this training corpus that might in turn result in, say, biases or the breach of personal data. So these are problems that are, to an extent, addressed in other fields of law, but the discourse on administrative law has not yet evolved to the point where it addresses these particular problems. And that's why we've indicated in this table in the middle column that these are not problems of administrative law. However, we believe that the administrative law framework needs to expand to accommodate new principles, particularly as we start talking about integrating emerging technologies into public administration in different capacities. So we offer these as provocations, perhaps, to help direct and deepen the discourse around administrative law and sort of think a little bit about how the principles of administrative law need to evolve in order to accommodate new challenges that come up with the use of such technology. So broadly, this is our statement of problems. We are also mindful of the fact that given the amount of interest in LLMs generally, in both academia and industry, this field is evolving at a really rapid pace. And the kind of problems that we will face will keep evolving. And the nature of the challenges they present will also keep changing. But we believe that the framework is useful in that a good starting point to ask questions of how we can integrate these tools into administrative practices generally is to start by articulating specific sites of tension between the capabilities of the technology and limitations of the technology and the principles of administrative law. So once you're done identifying these sites of conflict and problematizing them, you can then move on to find specific solutions to each of these problems. So that's the second part of the framework. Now, we propose that there can be 3 distinct categories of solutions designed to effectively address the tensions that you have articulated earlier. So the 3 kinds are technical solutions, design solutions, and systemic solutions. So very quickly, technical solutions are essentially those that are directly built into the workflow or functioning of the LLM application. So we know from anecdotal evidence, like the one that the incident with the income tax appellate tribunal, that general purpose off-the-shelf LLMs are simply insufficient for critical tasks, like the ones used in regulatory audit. Therefore, we propose that necessarily any LLM application used to assist in the audit writing process, must be custom made specifically for this purpose, 1. And 2, it must be designed in such a way as to deliberately incorporate technical checks and safeguards aimed at mitigating each of the problems that we've identified as being in tension or in conflict with the principles of administrative law. So one example of this is, for instance, the problem of hallucination. So let's think about the income tax appellate tribunal's controversy again. So there what had happened was that the LLM had hallucinated a few cases that didn't actually exist. One solution to such a problem is already present in most legal tech solutions that are available in the market today. And an example of this is retrieval augmented generation. So for instance, having a RAG model in the LLM application will ensure that the LLM's output is limited to a verified and accurate database to which it can consistently call back and identify the source of its outputs. And also, this makes the verification process much easier. So in this way, sort of building in a technical check into the workflow of the LLM itself is a helpful way to go about dealing with some of the tensions we highlighted. So the second type of solutions that we propose are design solutions. And by this, we mean solutions that are centered on how the LLM application's user interface is designed. So the main goal of design solutions should be to prioritize keeping the user in control. And by this, I mean that the user, and in case of order writing processes, the adjudicator, must be required and enabled by design to be able to check and verify the LLM's functioning at every stage of its workflow. And this needs to be built into the very design of the way that the LLM application is built. So there are two significant advantages to ensuring that the user is in control. First is it helps place a check on the accuracy of the LLM's functioning. It makes sure that at every stage of its functioning, its output is checked and verified, and that prevents the snowballing of inaccuracies. So as opposed to just checking the output, if you mandate that the user has to verify each step, then it ensures that the entire process remains accurate. And the second reason, perhaps a more critical reason, is that designing an LLM application this way will also serve as a mechanism to ensure that the adjudicator is actively applying their mind to the order writing process. So by mandating, for instance, that the adjudicator must review and sign off on every output that the LLM generates, and then also requiring them by designing to provide reasons for accepting or rejecting the LLM suggestions, this design acts as a way to place a check on the adjudicator's own function, ensuring that they apply their mind to the facts of the case.
So just cognizant of time here. So I'm just going to maybe pick up here and move on to the last part of the framework. We've talked about the problems and potential solutions, and I just want to leave up here the idea that you could think of certain evaluations to test the efficacy of these solutions as well. There are in the technical literature several different ways that are suggested to do this. And perhaps one of them is most familiar and most easily understandable for many of us who are not part of the conversation in this domain, which is the human in the loop. And so there are some solutions that could be automated. There are some solutions that could look at either end of the input and output cycle. There are some that would look at each step. And there are some that involve the human checking and verifying each step. But if you put it all together, this really is the framework that we've been talking about, that we've been describing. So on the extreme left, you have the 6 problems that we've talked about and what administrative law principles these do or do not map onto, and then the solutions and the corresponding evaluations for each of these. We detail all of these out in the paper that we're currently drafting, but maybe we don't have time to go through each of these right now. Very quickly, though, Amrutha, do you just want to point out the black box problem as one instance of how the framework works, and then maybe we can wrap up?
Yeah, sure. So, if you could move on to the next slide. So one way that we can go about this task is by start off is to start off by articulating the problem in terms of what the challenges are and when the technical capabilities meet the administrative law principles. So, for instance, with the black box problem, the core issue is that the reasoning is not explainable. The inner workings are opaque. So, once you've articulated the problem, you can then move on to identifying certain solutions. So we have passed these solutions from our reading of the literature that is available largely in public domain. So this could be through many different types of techniques. And you may notice that for each solution that we propose, we also indicate which category we think that the solution belongs to. And of the three solution categories, we think that multiple solutions may apply to the same problem that act in a way that's complementary and maybe pile on top of one another. Once you've narrowed down on your set of solutions, you can then identify ways to evaluate whether the solutions are working and highlight the efficacy of them. And if there are inefficiencies in any solution, find ways to iteratively improve them and sort of keep that feedback loop going.
As I said, we're looking at the 6 problems and corresponding solutions and evaluations and detailing all of these out as well. But let's just go on now to what all of this boils down to. So where we started was that the use of such technologies poses certain problems. We need to think of ways to address them. We've suggested one such. Even if you do, though, we think that the use of such technologies in such settings should be done in very limited and careful ways. Some of these are fairly self-explanatory, but some of these I think it's worthwhile spending a couple of seconds talking about. The first idea is that we're not suggesting that we build a system that will actually draft these orders and take that decision-making capacity away from the human decision maker. But there is certainly room to think of how these systems can assist and potentially review how these orders have been written. That's one. Another thing worth thinking about is the shadow and compare suggestion in the build stage, which is don't just go and deploy a tool like this once it is built. Once you have a tool like this, deploy it side by side alongside the human order writer and see how they compare. Satisfy yourself that they work and then go on to use them. Along with all of these technological solutions or suggestions that talk about the product or the technology, we think it's also critical that adjudicators be trained and retrained periodically so that they are aware of how these systems work, what the potential dangers and harms and shortfalls might be, and so that they use these in the manner that they might be intended. I'll stop there and invite any questions.